All right. Good morning, everybody. Thank you for joining all of us today on PINJ's next edition or latest edition of the Deep Dive series. This one is called Behind the Verdict. It's regarding social inflation and how litigation trends are driving insurance costs. Um, the association has put together a great panel for today's discussion. Just introduce those panelists, and we're going to dive into our conversation. Joining us is Alexia Cruz, who's Senior Vice President and Claim General Counsel at Travelers. She's got over 20 years of experience at Travelers, fantastic, and oversees a team of over 1,300 people, which is kind of mind-blowing to me, in both the legal side and on the claim side. She's got an extensive background in litigation, complex claims, and strategic legal oversight, and she's got some amazing information on the topic of social inflation and third-party litigation funding. I can tell you from our meetings leading up to this, she's got a ton to share, and I'm really looking forward to that. Also joining us is Lydia Bashweiner, who is General Counsel and Claims Manager at Otterstedt Insurance Agency. Lydia has a very unique perspective of being both an attorney and a licensed insurance agent, brings a great perspective, has been doing it for over 20 years and constantly communicating with clients about kind of the legal stuff, the litigation process, how much time it goes into a cost, expenses, things that clients don't often think about when they're thinking about insurance or claims like that. So really looking forward to bring her perspective. And then last but not least is Adam Juzieski, close there. Yeah, who's the president of Catskill River Affairs. He is PINJ's legislative liaison and is just incredibly clued in on public policy in New Jersey. He's been doing it over for 20 years and really helps the independent agents in New Jersey execute their legislative and regulatory vision. So he's going to be bringing a good perspective on where we are with legislation and regulation around the topic of social inflation and third-party litigation funding. Before we get into it, just a few logistical things, if you will. If you want to ask questions, you're encouraged to just throw them in the chat, and we'll try to work those in as we can throughout. In addition, we are going to have a little bit of time at the end, or try to allot a little bit of time at the end for questions. So we will have that, but don't be shy. Feel free to send us some questions ahead of time, and again, we'll work those in. So with that, we're going to get started, and I'll start with, I guess, maybe a really open question here, because we might not all know what social inflation is, and I'll throw it to you, Alexia. What is social inflation? What are we talking about right now?
All right, let's get into this.
Yeah.
Social inflation is a term a couple decades ago they came up with, but if I like to think about it as in if inflation is at a certain percentage, but your claim costs are outpacing the inflation you're seeing in the economy, then what's causing that? And it's a factor in the society. So we have that situation now where claim costs, the cost of a claim, is outpacing inflation. So we have a situation called social inflation, which I definitely feel like it started before COVID. So we'll talk about some statistics today, pre-COVID, during COVID, after, if that's helpful as well. Now, we have been thinking about this as an industry and having meetings on this for several years. And there's a consensus. I wouldn't say every single carrier or company, but we would like to call it what it is. And it really is legal system abuse. So you're going to hear that concept more often. Social inflation doesn't seem to fit. Legal system abuse doesn't roll off the tongue, but it's definitely a term we think is how we should be talking about it. So I'm going to try to rebrand a little bit today as we talk about this concept.
I like the idea of a rebrand. That's nice. And you make a really, really good point, right? Social inflation is like kind of pick almost like a word salad a little bit. Talking about legal system abuse is really more direct. So I'm a little bit of an example person. Would you be able to give us, I guess, some examples of this legal system abuse that you're referring to, Alexia?
Yeah, and I'll talk a little bit about why we would call it legal system
Yeah, that'd be
abuse.
great.
Certainly, the plaintiff attorneys have a lot to gain by the larger verdicts. So we'll talk a little bit about nuclear verdicts. And when we say nuclear verdicts, which is, I think, what caused us to start talking about social inflation, we're defining as over 10 million, but as it's moving up, you could hear it defined as over 20 million. But we'll talk about it today as over 10 million. So when you think about the plaintiff attorneys, you're going to see a ton of advertising. So a lot of the advertising is creating this awareness of larger verdicts and desensitizing jurors and getting jurors used to larger numbers and getting them to dislike, whether it's companies or carriers, this idea that the more volume and the more times people are hearing companies are bad, carriers are bad, we need to punish them. It's helping them when they go into the courtroom. Now, it used to be in my time, and I'm quite up there in age, a third. You give your attorney a third. Some attorneys still do that, but we're hearing a lot more about 40% contingency fees. So if you think about these huge verdicts that are coming out, 40% first goes to the attorney, then expenses, then to the injured party. That's a lot of economic incentive. So as we're seeing these verdicts go up, we have an obligation, our insureds, your clients, to pay what we owe if we're responsible for an accident. And if they're raising the amount that's getting paid for an injury or damage amount or an event, that affects us all. The price continues to go up. So that's some of the dynamics we're seeing. But there's also this, I talked a little bit about the billboards creating this anti-corporation sentiment, or there is a lot of discussion about this idea of populism, that companies, we'd almost be able to go to a juror and say, are you a Democrat or you're a Republican, and try to read where they might lie, defense, plaintiff orientated. Now it feels like we're getting more jury pools that just don't like corporations, and that's not by political lines. And that's something we are really looking at, and we feel like that's an interesting dynamic we're seeing in the industry as well. We're also seeing new causes of action. You'll hear about public nuisance, or you'll see attorney general actions being filed in states, and they're actually using plaintiff attorneys with the contingency fee to bring all these cases. So this is something that didn't exist before. A company may be charged with causing pollution with their company, or the opioid epidemic. Just because it exists and it hurts society, this is now a cause of action. Which didn't exist before. And so that's something that we haven't seen before. They're creating new causes of action, and class actions are increasing. Why? Because all of that goes to inflate how much the plaintiff attorneys are getting paid. In a class action, they get their ×3 of attorney's fees, so why not file more class actions? And a lot of this is about putting less money in the pocket of the person who's injured and more money in the pocket of the plaintiff attorneys. So those are a few of the reasons. Some of the things you'll see with that, and we'll talk about a little bit today, are litigation funding, which we'll talk about in a little bit, but jury anchoring. So that's when you'll hear that term as well, related to social inflation. So plaintiff attorneys, they have a lot of incentive, I've already said that, to work together to increase the amount of money they get back. But what they do is they partner together and they share strategies. So one of the strategies that has worked for juries is jury anchoring. So in opening, they may say to a jury pool, are you sure, 10 million is a lot? Do you think 10 million is something you could award? Well, 10 million seems like a lot. Is that something you're comfortable with? Then they say to another juror, they keep saying 10 million, 10 million, 10 million. Now the jury, after the case, they go in the jury room and say, I don't really know how, but 10 million seems to be a good number. And it's been a psychological, planting that seed. This is in voir dire. This isn't even at the trial yet where they put on damages. They're just putting these numbers, and it could be reality stars or, just these numbers that get planted in there. So you'll see some efforts trying to preempt that through motions.
I'm going to pause you there. Would you mention voir dire, what that is real quick?
Voir dire is how you select, it's the process of how you select a jury in whatever jurisdiction you're in, we call it. And then down south, I know they call it voir dire. We do, in New England, we do voir dire. And then
can I just interrupt for a second? Sure. In New Jersey, we have some more guardrails around attorney fees. We have rules of court, which restrict attorneys' fees, and they're actually laddered. So you get a third of the first X number of dollars, a quarter of the next, and it decreases. In juvenile cases, they're restricted to 25%. Also, you can't ask for a dollar amount in New Jersey state courts. You can't. You can calculate, actual calculable economic damages you can list. But then the big thing in personal injury cases, obviously, is the pain and suffering. that the unquantifiable aspect of a damages award, which is, how long did I have to, did my back hurt, or did my neck hurt, or, that period of time, what couldn't I do that I did before? All of that is, all of that comes out in discovery, which is the process prior to trial, where you ask written questions and take depositions, which are oral questions. And then defense attorneys are able to sort of, based on that information, put a number on what they think the value is of a case.
No, it's a great point. And then those are things to protect. Those are positive things, I think, in New Jersey, the
Yes.
fees and some of those aspects. So when you think about legislation that's being proposed, those would be things you'd want to protect. Along those lines, with actual damage, the phantom damages you'll hear of in other jurisdictions where that's billed medicals, not paid medicals, which means they may never get paid. And so Florida, with their recent tort reform, and then Louisiana followed, they're trying to make it more strict that it has to be paid, not billed. And there were a lot of activities going on with medical providers to collude to put a number, and then they had payment plans on the back end. So that is something that's drawn a lot of attention, that was causing some inflated economic damages if they can board that. And then the reptile theory, I think, is important to talk about when I think about your customers, because that is a very successful strategy. It's a strategy that the plaintiff attorneys use to appeal to the reptilian fight or flight part of your brain, which means they want to have you have fear. So when you think about negligent premises cases or safety cases, it's this idea of, could you have done something else to have prevented the accident or the situation that happened? Now, your insured, your customer, our insured, could have done everything possible to comply with the building code or the construction safety regulations. It doesn't matter. They get to a deposition and they get this individual to admit, yes, I could have done something more. And that's used through trial to say, don't you admitted in your deposition that you could have made it more safe. You could have prevented this incident. You could have, and it really is effective with jurors who feel this sense of, I want to punish, and this is how I'm going to do it, regardless of what the law is. And so the one thing I'll leave you with is, if you have a customer who has safety protocols, tell them to follow them. That's probably the biggest thing I see in the safety cases, is that if they have the protocols and don't follow them, jurors are tougher on those individuals as opposed to not having them at all, which is a crazy thought, but it's really interesting. So those are a couple of the things, Bradford.
That's been my experience with our clients as well. We always stress safety. One of my colleagues is on this call right now, and he I know works tirelessly with one of his clients for safety meetings, and every possible, they do a lot of transportation of goods, and he works tirelessly to get them to adhere to have a safety policy, and then to adhere to it, because it's a great defense. That's, we can get to that a little bit later, but being proactive prevents the claim to begin with. And if you can do that, that's half the battle, right? It's more than half the battle, I guess, because then you don't have to worry about litigation and the time and expense to you as the client, as the defendant. I've been a defendant, and it's not easy to. It takes a lot of time, mental and physical time, away from your normal activities that you would that you need to do every day. And I think it's really important to stress that with our clients.
So one term that you mentioned, Alexia, that I really want to return to is nuclear verdicts. And I would love to kind of talk about, I guess, what that is, and maybe like some of the verdicts that we're talking about, just to kind of put it into context. And with the realization that, while we're talking about New Jersey, right, litigation costs around the country do end up impacting New Jersey rates, whether it's happening in New Jersey courts or not. So with that, Lydia, I know that you kind of dug into this a little bit. I don't know if you'd like to maybe just kind of throw
Sure.
something out there.
Sure.
Well, yeah.
Yeah, there's some cases that I came across actually earlier this month, and there was a jury in Los Angeles. it was a case where a woman, her family sued because she died. She had mesothelioma, which they claim was caused by exposure to the Johnson & Johnson talcum powder that contained asbestos. And the jury awarded $16 million in compensatory damages, meaning her damage, and then $950 million in punitive damages to punish. So there had to be some evidence adduced at trial that showed that they knew, right? Because punitive is to punish, to keep you from doing things. And generally speaking, these were awarded when you knew you shouldn't be doing something, like with the tobacco cases from, the 60s and 70s. You knew you shouldn't do it. You knew it caused a problem. You went ahead anyway because you did your cost benefit analysis, and it was cheaper to go that way than to pay this ultimate almost $1 billion verdict. So that was pretty big. That's a big verdict. It wasn't in New Jersey, but it does, it was recently. That's why I talked about it. Last year, there was an Essex County jury, and the venue is very important in determining how to approach settling and resolving cases, whatever venues or what county. In New Jersey, we have 21 counties. And there was an Essex County jury that returned a verdict of $55 million for a woman who had suffered a double amputation of both of her legs when she was hit by a truck. That's a pretty nasty injury, but 55 million is a pretty high number.
Yeah.
Also last year, an Atlantic County jury awarded $37,548,096 to a 16-year-old boy who had hemiplegic cerebral palsy. The allegation in that case was that the doctor did not properly manage Pitocin, which is a drug given during labor to speed it up. And it caused in this case, it caused excessive pressure on the brain of the fetus. And that caused him to have a stroke. And he ended up with hemiplegic cerebral palsy, $37 million. So that's like a lifetime of medical treatment and all of that. So that's the types of awards. They're big. They don't have to all be that big. And I don't know what the specific circumstances. There's a lot of factors, right? How that go into a defense attorney's assessment of what a case is worth, what the settlement value is worth, and what the jury verdict value is worth. And sometimes there's a big gap between the two of them.
And I will just add that there's a lot of things going through my head as you're going through all the nuclear verdicts, but we study a lot of these larger verdicts. And when you do start learning about the case, you'll find some factors that were particularly inflamed the jury, whether they say they didn't offer something, or there was just a fact that was particularly sad or egregious. And so when you take a lot of the factors, or the medical malpractice one that you mentioned, there is that ability to, earlier on in the case, when you see some of those factors, to have that discussion together with your carrier insured customer. Is this a case we want to settle, or is this the one we want to try? Because a lot of times you read it and you're wondering, why did they try that case? And then you kind of put things together. The other point that was going through my head is, a lot of times these very large verdicts, and Philly had a couple very large ones, they get reduced. So, the headline is 950 in punitive, and I don't know what'll happen in that case. But if it gets reduced on whether it's called remittitor, which is the judges can decide to reduce the amount because it's excessive. Usually the model for years was a Campbell case ×3. So it shouldn't be, your punitive shouldn't be more than ×3 your economic damages. So if your economics go up, your non-economics can go up as well. But a lot of them get reduced, but you never see the billboard or the article that says this is now reduced. So we at our company just had a recent one in New Jersey, very recent, for $15 million that was reduced to I think it was 100,000 or something. But nobody goes back, and you don't hear about the reduction of the cases, and I do think New Jersey, I sit in Connecticut, there are reasonable judges who will look at things and right size them, but we don't get that narrative either. So I think it's important for people to understand, yes, it's a big verdict. Does your client want to live with that, or the insured? Because we are having some successes at the appellate level. In 1 week, Texas reduced 3 nuclear verdicts at the appellate level, and 2 of them were trucking cases. So I was very surprised. So there is this belief in the industry now, should we be more aggressive on appealing these and getting them reduced so that the bar and the standard isn't that high, over $100 million.
It also, the costs are more, right? So you get a verdict like that. So the first thing that you can't just immediately run to the appellate court. You have to go through a lot of the civil procedure process of motions, post-trial motions, motion for new trial, motion for remitted, or if you didn't think you got enough money as a plaintiff, there's something called additor. You can ask for more, ask the judge to give you more money. Doesn't often happen, but remitted or does happen more. So then there's all of these post-trial motions, motion for new trial and briefing, and takes more time. Then if that's unsuccessful and the parties still want to pursue, I mean, you can discuss settlement even at any point after the verdict, by the way. Cases do settle because they know there's going to be a protracted appeal. They know there may have been some errors during the trial that would cause this just to continue and cause the plaintiff to not get the money, any money, or put it off, and the defendant to have to spend more money to prevent them from paying the money. So there is always an opportunity to settle. And I think you probably find that, Alexia, that there's, people, depending on the case, again, very fact specific, and also fact specific in regard to who the plaintiff and plaintiff's attorneys are, and the carrier as well. Some carriers are a lot more willing to spend the money than others. That will dictate.
Yeah, I was going to say that's a great point. If I think about some of the jurisdictions outside of New Jersey, the prejudgment interest and post-judgment interest can be very high. So a lot of those cases get settled just on the fact of, if I'm wrong on the appeal, I'm also stuck with interest on top of the verdict. And so I had mentioned, it made me think a lot of these plaintiff attorneys with the incentive to put money into politicians and judiciary. So New Jersey, like Connecticut, they're appointed, so you have some protection, but they're elected in other jurisdictions. So when they're elected, there's millions of dollars, and we've confirmed that with plaintiff attorneys funding candidates to get their candidates on the judiciary. So at the state court level, we do, in some of these hot jurisdictions you may read in the judicial hellhole report, they're stacked with plaintiff attorneys. So at that state court level, you could get all kinds of crazy rulings. And to Lydia's point, that's where you have to pay particular attention to appellate issues and whether you want to appeal, because there's a lot of mistakes and things getting in at that state court level intentionally, and to get the big verdict. And that's why we've had some success on appeal. But that's another thing we're thinking about, is how do we get more defense attorneys on the judiciary so it's more balanced?
So before we transition over into third-party litigation funding, I wanted to ask Adam a question related to some legislation that's going through New Jersey that would actually, I'll let Adam go into it, would impact insurance companies, how they're listed on court cases. So Adam, would you mind just talking about S-4499 real quick?
Sure. Yeah. And S-4499 is a bill that's sponsored by Senate President Nick Scuteri and Republican Senator John Bramnick. Speaking of plaintiffs' attorneys, they are both plaintiffs' attorneys by trade and in their profession. So one would imagine that often shapes their perspective as they craft and create legislation. This bill in particular requires defendants, including insurance companies that are named as defendants, to be properly identified in any causes of action. So I saw there was a question in the chat as well about isn't New Jersey trying to prohibit the inclusion of insurance companies? Currently, I'd say at least the only proposal we're aware of, it's actually doing the opposite. It is trying to include insurance companies in being listed in causes of action. And again, that is, as we've mentioned before, Alexia and Lydia have talked about plaintiffs' attorneys and the effect on the judiciary. We're seeing that in our legislative branch here in New Jersey, again, because the Senate president, who's one of the three most powerful lawmakers in the state, is himself a plaintiff's attorney.
The trial attorneys contribute to campaigns? I had no idea. That's shocking to me.
And that bill, unsurprisingly, found its way through the Senate pretty quickly. There is no assembly companion. I know we were sort of planning on talking about the upcoming lame duck session later on in the session, but just putting a pin there we can go back and explain what that means. Cool. And the prospects for this bill as the session's going to come to a close in the middle of January.
Awesome. Thanks, Adam.
And we're finding that, I was just going to say, Bradford,
Yeah,
that we're
please.
finding that jurors are so sophisticated. It doesn't matter if the carriers are named or not. They know there's insurance involved. You may have a rape on a premise and the perpetrator gets zero liability and the owner of the parking lot gets, the bulk of the liability, and you scratch your head saying, how can that be? But they know, okay, that person's in prison, they can't pay, so I'm going to put the liability. They're just so sophisticated now. So there's things that you have to think about as you go in, and how do you present evidence?
Well said.
Yeah, well, you can't, I mean, if you're in an auto accident trial, you just can't say, insurance company, you can't mention insurance. You can't. It's not relevant. That's why you can't mention it, because it's not, whether someone has insurance or not is not relevant to the issues of liability and damages, which is why you don't mention insurance. If they're a defendant, if an insurance company is named as a defendant for some reason, obviously that's different, but you can't talk about, doesn't this guy have insurance or whatever? It's not relevant to the issues that a jury has to decide.
So with that, I'd love to transition over a little bit and kind of dig in to a third-party litigation funding, which is a term, if you haven't heard before, you're going to. It's something I don't think I can go a week without talking to somebody about. It just seems to be kind of the talk of the insurance industry, if not other places as well. So I guess to start that conversation off, I'm gonna go back to Alexia here. Would you talk about what third-party litigation funding is exactly, and maybe, where we see it in the wild, so to speak?
Sure. And talk about making money. So
Yeah.
plaintiff attorneys are making money, and so are third-party litigation funders. And there's a lot of opportunity. So I'll get a metric from Bloomberg in 2019. They said the litigation funding potential was worth 39 billion. And that was in 2019. So that's pre-COVID. Now, as we fast forward, there's projections of it being worth 50 plus billion dollars of an industry. And some of that's because Swiss Re reported in 2021 that 17 billion was committed in capital to fund, to do some of this litigation funding. Over 50% of the lit funding, though, is in the U.S. We do have a Europe issue, and they're addressing it as well, but a lot of it's in the U.S. And so I'm going to talk first about what we're hearing in the news and this larger investment. Burford Capital is the one probably a lot of people are familiar with. It's these hedge funds that are investing large amounts of money in some of these larger suits. Some of them, the public nuisance ones I mentioned, they will fund the suit to get a big return on investment. So Burford, so now the projections are 50 to 100 billion for what it might be worth in the future. But since the inception, Burford Capital has a return on investment of 26%. It was as high as, I think, 30% at one point, worth 3.3 billion in realizations. And as of year-end 2024, their portfolio for litigation finance was valued at 5.2 billion, and it's probably growing now as we're going into 2025. But think of that as the hedge funds investing in large cases. It could be intellectual property cases. It could be the big opioid cases, the large. It could have been tobacco back in the day. And so that's one type of financing. A lot of your customers or carriers you work with may not be seeing that if they don't have the patent or the intellectual property. So there's another type that we talk about, commercial funding and consumer funding, that are a little bit different. So the commercial funding, think of that as the Burford Capital large hedge fund funding. That's getting a lot of traction. And if I can segue on that a little bit, the U.S. Chamber of Commerce has done a lot of work exposing the foreign investment. So think of large companies, whether they've got a lot of traction with some cases involving China or Saudi Arabia. So if these companies are investing foreign investment in our intellectual property and patent cases, because they're involved in the case, they're getting access to some of our most coveted intellectual property and patented technology in the US. So that really got people's attention and got us some traction in having this ability to get disclosure of the litigation funding agreements to see, okay, well, they can see the discovery and how does this work? And so consumer funding may be something that you're seeing more, or your clients, customers, and insureds are talking about more, because that's more direct loans to the plaintiff. So you can do a direct loan to the plaintiff to say, don't worry about expenses, I'll invest in the case. And they'll say, if there's no return, if you don't get a settlement or there's not a judgment, you owe me nothing. But that gets them out of that, all the regulations that a bank, getting a loan from a bank would have. So that you'll see interest rates of 20, 30%. If there's no return, then the plaintiff owes zero. But typically there's something. Remember, if there is a return, though, you pay a contingency fee to the attorney, expenses, and then the consumer loan with the high interest rate. And then medical financing is what we see a lot more frequently in New York and New Jersey, with some of the attorneys as well as the doctors are combining with the plaintiff attorneys. So this is more like someone gets injured and the plaintiff attorney will say, even though you have insurance, don't put it through insurance because your uninsured rate is higher. You'll get charged more. We'll have this finance company come in and pay for those. You don't have to worry about it. And they don't talk a lot about how high the interest rate is. And then the case will go on, they'll get more surgeries, the economics will go up, and then at the end, they'll owe this money back if there's a recovery. But we see a lot more, that's the volume we see, is the medical financing agreements. And in the end, it's really the injured party who ends up with a lot less money than they would have had they resolved or not gone through this process to begin with. So it's sad for the person who's injured, but very lucrative for the medical financer as well as the plaintiff attorneys in these cases. So if you think about those different buckets, you would then have a discussion about, well, what can we do about it? What do we want to do in the industry? So as I mentioned, there's a lot of traction with the hedge fund investment and the foreign investment idea of how can we get disclosure, whether it's in federal court or state court. And New Jersey is one of the few federal courts that has decided to have disclosures within 30 days in federal court of certain terms, not the entire agreement, but whether there's a funding agreement in place. There's only a couple other states that do this. And then what's the involvement in settlement? Now, that's a critical question because these agreements have to be with the plaintiff. They cannot be with the attorney because there's a conflict. That means they have a say in the outcome of the case, which they're not disclosing. And then you also cross over into the unauthorized practice of law. So there's a lot of technical issues that they've thought through, but a lot of us are thinking, but it still feels like this isn't the right thing because you are able to stop a settlement between a plaintiff and the party trying to resolve the case because you have your agreement says you have the right to accept or deny a settlement. And so you'll see some of those cases being in the news recently. So that's, in my opinion, it has contributed obviously to social inflation. It's putting lawsuits out there that wouldn't normally be out there, and it's putting a lot more money in, and it's slowing down our ability to settle cases across the industry. But even transparency itself, you'll hear people say, okay, now you have the agreement. That didn't solve social inflation. We just have the agreement. So we are creating data banks, and I know the Chamber of Commerce is, we do it at Travelers. We take the financing agreements that aren't confidential, they're disclosed confidentially, and we create a database and we look for terms, and we, have some, and we, not every jurisdiction you can get at the agreements, but in New York and New Jersey, we're able to get agreements and look at them and see what companies are the most active, and then look at, is this right? Is this appropriate? Is there a technicality here that they're violating? So it's really interesting, but it's very technical. And we can talk, I don't know, Bradford, where you want to go with this, but what we're doing state and federally to oppose it.
Yeah. I appreciate that. So I guess one thing I do want to mention, I'll back up just one step and mention that with third-party litigation funding, what the funding party is, what they're loaning against is the value of the case itself, right? So as opposed to a traditional loan where you might be loaning against the value of a home, a car, or whatever, an asset, the asset in this case is the actual case itself. Which makes it a little bit interesting, or very interesting in terms of how it works.
Yeah, the funders have to do their due diligence.
Yeah.
To make sure. I mean, when you have a mortgage or any loan, a lien against a house, that's something that you can put a value on. The value of a case can be In some cases, nothing. If the jury comes back and awards nothing, and in some cases could be more, and it's really hard to determine what that's going to be. Now, there's lots of ways to track verdicts and to get a sense of typical verdicts, typical types of cases, what they return, and that's always what a defense attorney has to consider when looking at these cases. And now they have to consider this third party funder. And that, to me, as an attorney, I was in private practice before I joined Otterstedt, and your duty is to your client as plaintiff and as a defendant, both. And when you allow anyone else to come in, and, even though they're paying for it, paying for some of it, you are really compromising your ethics. You could be compromising your ethics. You just can't allow that to interfere with your judgment and your advice to your client. And as a plaintiff, it is up to the plaintiff to accept or reject jury, a settlement. Jury verdict is a different story, but a settlement is totally. I mean, you might want to continue, and you give your strongest argument for that. And if the plaintiff says no, the plaintiff says no, and that's it. Case is over. So you have to, you can't even put your own interest, and a lot of attorneys, by the way, in New Jersey, particularly the plaintiffs, they have money invested in it. They have paid the expenses. They have advanced filing fees, deposition costs, expert witnesses, all sorts of things. They've got a lot of money in every case. In New Jersey, expenses come out first. So you get an award or a settlement, expenses first, and then fee is on the net. The attorney fee is net after expenses, and then what's is left is for the plaintiff. So that's definitely that's a consideration. And that I mean, as an attorney, I'm offended when there's somebody else trying to dictate what happens in my case. And I know I've tried to explain this to insureds, because now I'm in this part of the business, and to try to have that relationship, explaining reserving and why cases are reserved the way they are. That's huge. We always try to look for reserve justifications from adjusters and supervisors. Why are you putting this number on it? Why are you doing that? So sorry about that. And with litigation funding, those cases can tend to last a little longer because they've got an investment, and that drives up the costs, and it keeps the reserves on the books longer. And that makes clients and producers, insurance producers, a little bit crazy.
You mentioned what goes into like these litigation funding companies, like doing research. I can tell you that. So I used to work for one of these companies 20 years ago. My first year out of law school, it was like a summer job, right? And I can tell you 20 years ago, it was very sophisticated, right? They get a file in, and they take a look and see what the injury was, how old the person is, where the case is filed, what that county has gone, like what jury awards in that county were in the past for that injury. So even 20 years ago, the stats and the data was pretty intensive, and they weren't picking cases where there wasn't a high likelihood of return. So I can only imagine that process has become more sophisticated. So yeah, they don't pick many losers, I would think. So with that, we did talk a little bit about legislative stuff, and I'd love to transition over there to talk about maybe the solutions on this. So with that said, let me actually go to Adam first, since we're talking about New Jersey. Adam, would you mind just giving us a little 101 in terms of New Jersey legislative process, and maybe where we are right now in terms of the legislative session, maybe the leaderships and that sort of thing, just the players,
Absolutely. So I'll give you a quick, I could talk about legislative process all day, but we'll give you a quick 20-second primer. And if anyone has any subsequent questions, happy to answer them if you put them in the chat. But basically, you have a bill that's introduced. The legislator will introduce a bill. We call that sponsoring in either the House or the Senate or both. The bill is then reviewed or amended or voted on in committee. Most of these issues would be considered by either the Assembly Financial Institutions and Insurance Committee or the Senate Commerce Committee, or both. If approved by the committee, it then advances to the full respective chambers for a vote. The process basically repeats in the other house. So if there's a bill that had moved in the Senate that makes its way to the Assembly, same process happens, or vice versa. And this could happen either sequentially, as I just described, right? Goes from the Senate to Assembly or Assembly to Senate, or the process can actually happen concurrently, where both houses are moving identical or similar pieces of legislation at the same time. If both houses pass the bills, then it goes to the governor for their action. And in New Jersey, the governor can either sign a bill, which means he or she approves it. They can veto a bill, or they can conditionally veto it, which means they will suggest changes to the legislation, almost as if they were a member of the legislature themselves, and then send it back to the legislature for approval. In New Jersey, we're currently in the second year of a 2-year session, really on the back end of it. We have elections coming up in November. The legislature is not scheduled to meet until basically that those elections are decided. We have a governor's race, and then also our full assembly is up. Once that happens, we're gonna start what's called a lame duck session. Basically, this is the time after the election, but before the new legislature is sworn in. From my standpoint, and from what I've seen over the last almost 20 years of doing this, lame duck sessions are often very consequential because it's a stretch where lawmakers who are leaving office, either because they've retired or they lost their reelection, can take politically risky votes. It's also a time when leadership moves maybe more controversial or long delayed bills because, you know, an election just happened and it's something that they won't necessarily have to worry about for the next 2 years or maybe the next 4 years, depending on if you're in the Assembly or Senate. And because of that, you know, and they're aware that we often have, as a public, a short memory. So, you know, they'll more inclined to take on controversial issues immediately after an election and when there's some distance between the next one. So for anyone tracking bills that affects the insurance industry, such as what we do at Pat's Government Affairs and PIA, it's really a time to pay close attention to what's going on.
Thanks.
So, and then Brad, you asked about key players and leaders.
Yeah.
So, you know, but again, I already mentioned Senate President Scutari is a plaintiff's attorney. And I want to be clear, you know, it shapes his view. You know, he's deeply familiar with litigation and particularly from the plaintiff's side. I don't want to make it sound like that motivates all of his actions as it relates to legislation and insurance, but I think it does play a role in how he approaches legislating and what you know, where he comes from. The Senate Commerce Committee, actually, which is again the committee where a lot of insurance related issues go, is chaired by Senator Joe Logana, who is actually on the other side. He's usually a defendant's attorney. And then one of the members of that committee is John Bramnick, who, while he's a Republican, is a plaintiff's attorney as well, hails from the same county as the Senate president, and they both came up in their careers together and are pretty closely aligned on a lot of these insurance and litigation related issues. On the Assembly side, Speaker Coughlin is also an attorney. He's more or less, his practice is more or less municipal law, but they do often get involved in litigation too, and more often from the defendant's side, I think, as well. So there is this sort of philosophical, you know, tug of war between the leaders of the Senate and the Assembly on how they approach litigation issues. Current governor is not an attorney, and I don't know how often that affects his views on these matters. I think it often comes down to political considerations on whether or not he's looking to approve a bill and what the Senate president and the Speaker both want. I think if Mikey Sherrill, who's the Democratic candidate for governor, wins the election, you'll probably see some continuity with that approach. She is an attorney, but she was a JAG attorney. She's not, I don't think, really litigation. If Jack Ciattarelli wins, who's the Republican candidate, you know, he'll generally characterize his approach as being more business friendly, and he'll talk about reducing costs and streamlining regulation, which, you know, can often mean deregulation. So I think if there may be more of an opportunity for an administration-led discussion around litigation transparency or tort reform if there's a change in parties here. Again, not guaranteeing that there'll be any results from that, because the Senate president is going to be the same Senate president when the new governor takes office. So I think that's a huge consideration on where the legislature goes and the governor acts from here.
Thanks, Adam. That's fantastic. before I'll have some questions on state litigation, but I don't want to totally ignore federal stuff. Because there are several federal, I guess, bills and things being considered. Alexia, I don't know if you want to touch on this at all. I'm happy to but I guess I'll throw it over to you for anything you want to say here before we, I guess, go back into the state stuff and then we finish up with some questions.
Sure. We had one bill that went through the federal government along with the California wildfire around that time, at the beginning of the year, that ended up failing, but was going to tax the recoveries on the third party lit funding at a 40% rate, and we would have taken anything on that. So that would have substantially, why it was related to that is there was a lot of lit funders interested in buying claims out in the California wildfires, and to prevent that, they wanted to have a financial disincentive, but it failed. So that didn't go through. But there are two bills pending now in the federal legislation that will be supported by quite a few of the industry groups. So one is HR 1109, called the Litigation Transparency Act of 2025. Representative Darrell Issa, I guess, is sponsoring it, and that would require disclosure of the agreements in all federal civil cases. So New Jersey has their own local for federal cases, but this would help us do that across all the states. So we're really going to push that because, again, with transparency, we can understand what the terms are and whether there's anything unethical going on. And then there's the HR 2675, the Protecting Our Courts from Foreign Manipulation Act of 2025, sponsored by Representative Ben Cline. And that would increase transparency and oversight of third-party funding by foreign persons and prohibit funding by foreign states and sovereign wealth funds. So that gets at that issue I talked about before, having the foreign funding groups come in and get access to some of our protected intellectual property. And I won't weigh in. Adam probably has a perspective on which ones are likely to go forward or not. That's outside of my expertise, but we're certainly supporting that as an industry.
Thanks, Lexi. And I don't know if this is a fair characterization or not, but it seems like looking at the federal stuff, a lot of the concentration there is maybe on the commercial side of things when they're looking at these the hedge funds and things like that in terms of national security and whatnot. And maybe the state level looks, I don't want to say they're ignoring that, but there is a little bit, I guess, more of a look at the plaintiff side. So with that, let me turn it over to Adam. And would you mind talking about the state legislation real quick? And honestly, I'd like to finish up with Lydia just to talk about advocacy too. So Adam, if you don't mind talking about the state legislation, where kind of we are and what it does, that sort of stuff.
Sure. And there's a set of companion bills that are specific to third party litigation funding agreements. And I'm not overly familiar with the federal legislation, but the way Alexia just described it sounds pretty familiar with what we're looking at in New Jersey. That would be Senate Bill 4374 and Assembly Bill 5566. And basically they require the disclosure of a third party litigation funding agreement, and it establishes other disclosure requirements as well as certain responsibilities for the litigation funders themselves. The sponsors' stated intent of the bill is to increase disclosure and transparency. The sponsors, there's two prime sponsors, one being Senator John McKeon, who again is himself a defense attorney, and then Senator Lagana, who chairs the Senate Commerce Committee. This bill is actually passed out of the Senate Commerce Committee, which at the time we as PIA supported the bill along with scores of business groups and others in the insurance community. And I would include in those business groups the New Jersey Business and Industry Association, New Jersey Chamber of Commerce, the Johnson & Johnson had supported the bill. So you're talking about sort of big players here in New Jersey that were supporting it. And the only entity on record that opposed it was the New Jersey Association for Justice, which is the name for the Plaintiffs' Attorneys Association. So for whatever that's worth, they were opposed to the bill. It's still passed out of committee by a vote of 4 yes votes to 0 no votes and 1 abstention. The 1 abstention came from Senator Bramnick, plaintiff's attorney. But the committee had finished the hearing with the sponsor saying that they are going to try to work diligently to address the concerns raised by the New Jersey Association for Justice. That being said, that that's rhetoric that's often spoken in Trenton, and it doesn't always produce results in terms of a modified bill. So I would say, at least from my view, in their current form, both the Senate bill and the Assembly bill, which has not moved in the Assembly yet, face an uphill climb to get done by between now and the end of the session. Again, just knowing who our Senate president is, and knowing, there's other plaintiffs' attorneys in the legislature, that it's one of those bills that unless it has a decent amount of modification between now and the end of the session, it's probably not going to go too much further.
Makes sense.
That's really kind of sad, because one of the things I liked about that piece of legislation is the fiduciary duties and restrictions on the funders, that I think is the ethical core of this. They would be subject to a fiduciary duty to the party that they fund. They're being prohibited from influencing the decisions, legal decisions. Take this deposition. No, don't take that deposition. That sort of thing. Offering legal advice, because as Alexia mentioned, that's the unauthorized practice of law unless you're a lawyer licensed in the jurisdiction in which you're purporting to give the advice. Attempting to secure a particular amount or limit it a particular amount, and to receive more than 25% of the proceeds, as well as, and combined with what the attorney would get, that can't exceed 50% of the total amount. So that would help to really narrow down the influence, which I think is critical in the New Jersey cases, but in the larger cases with intellectual property and foreign governments, that there's a different analysis for that. But I liked this piece of legislation a lot. As an attorney, I do, and I've been on both sides, by the way. I've been plaintiff's attorney and defense attorney, so I wear both hats. So I'm not one of those bad guys.
And I'm not saying it wouldn't.
Attorneys think, attorneys. Oh, the attorneys. Some of us are good.
We're not a monolith, right?
Ethical.
Yeah.
And I'm not saying it's
Alexia?
impossible. It's certainly possible. I just think it would, in their current formats, might need some more work in order to get some of the opposition cleared.
Right, the consensus. You need to get the consensus, and then maybe it's percentages or whatever. Maybe there's certain things, but I think the core for me is the fiduciary responsibility and the transparency, the disclosure. People need to know, and our clients need to know.
So you mentioned the word influence, Lydia, and I'd love for you just to touch on quickly a little bit about how, I guess, agents, producers can help, I guess, influence the issues in the legislature, right? Bills like this, Adam just said, it faces an uphill climb. If this is something we're really passionate about, how does an agent help push this or another issue across the finish line?
Here's my commercial. Join. Well, if your PIA members, that's great. But we also have the PAC, our Political Action Committee, and I'm treasurer of it. And Mike Beckerman's on here, and he's the chair of it. And there are others that are here that are on it. And it's so important to join PAC and donate to PAC, so that we can help to influence by. Not just with money, but we have meetings too. We want to hold meetings, one-on-ones with assembly and senators on issues that are really important to us and to our clients. And what an individual agent could do is, if you have a relationship with an assembly person or a senator, make a phone call, send an email. Don't think your voice shouldn't be heard. Your voice must be heard. It's everyone's right to have their voice be heard on these issues, and do it through PIA, a contribution to PAC, or ask us what you can do. We a lot of us do have relationships with individual senators and assembly people, and we reach out and we say, hey, we need to talk to you about this. And I think when they hear from constituents directly, particularly constituents who are donors, that does have a little bit more, it carries a little bit more weight, and it should.
And Lydia, if I could just add to that too, I mean, in terms of meeting them, right? I mean, if you're looking to do so formally, I would suggest coordinating that through PIA, through Brad or and then subsequently us through Katz. But they're running for election right now in the assembly, and they're going to be knocking on your doors and appearing at community fairs, or maybe even no more petition signs, but they'll be, or petition signatures, but they'll be at your train stations asking for your vote. I mean, this is the time where they're going to be most active out in the community. I think if you see somebody that's running for office, whether they're a sitting legislator or a challenger, it's a good time to, don't run away from them. Introduce yourself. Tell them what you do for a living and that you're a member of PIA, and that, if they are successful in their election, you'd really like the opportunity to set up a meeting with them going into the new session, particularly if they're a new legislator, because, if we catch them when they're green, it's a good opportunity to sort of plant the flag on the education on our side.
Yeah, well said. I think it's easy to get jaded and disenfranchised with democracy sometimes, but I can tell you that the grassroots outreach, it really does. It's impactful. It really does matter. So I do have one final question before I guess turn it over to the crowd if they have anything additional. We've been talking a lot about what we're facing now, right? What's the industry currently looking at with social inflation and third-party litigation funding? What are the emerging issues? What's the next thing? When we're meeting a year from now or 2 years from now, what are we going to be talking about then? I'm curious about that. Alexia, would you mind weighing in first?
I'm not sure.
Put your fortune teller hat on, whatever.
Yes, I think they're going to continue to find and just so people know, I did do some plaintiffs work early in my career, so I was on both sides as well. But I do think they're going to continue to find ways to increase. They're going to try to increase caps. I think the answer to this would be to have more caps, even if they're higher. But we're seeing efforts to increase. These are caps to non-economic damages, help us predict the outcomes of the cases better. So I think that's going to continue to be an effort on their part, as well as changing legislation so that they can have larger verdicts any way they can get in there. But I do think AI has been really interesting. It's allowing the plaintiff attorneys to just do more volume and to do their work quicker and take more cases and just really disrupt us a little bit more with a more volume of cases and different types and being able to write more motions and cases quicker. So I think that's going to be an interesting one to monitor and see how that affects our entire industry.
I think AI also can be a cost driver too, because people can do deep fakes, as we've seen. We tell our clients, if you have trucks, put cameras in them, those can be faked. And now everything can be faked, right? So you have to take a real good look, and then you have to hire the expert to prove that it's a fake. So that's going to cost more money, and that's just going to, and it's also going to delay the process. And the longer the process goes on, the more expensive it is. There's no question about that. So early settlements are helpful if possible, before these things happen, and being realistic. And from our perspective as agents for our insureds who are embroiled in litigation, they need to stay on top of things. They also can be advocates, by the way, not just agents ourselves, but we can also tell our clients, look, there's legislation that could be beneficial for insureds, people like yourselves. And if you, again, speak out. But I am concerned about AI and how that's impacting or could be going forward, because it's just exploding now. It's absolutely exploding.
Yeah, I don't think I can avoid AI in conversation. Adam, anything to add?
Yeah, I think on a more practical level, we've already seen a new law it's probably about 14 months old now, that increased the attorney's fees caps on workers' comp cases. So, sort of as one thing goes in Trenton, other things go from time to time. So that might be something that's looked at. And as well as, if the disclosure bills or the third party advertising, doesn't change, I think that's something that's going to continue to maybe, to Alexia and Lydia's point about AI, there's going to be other new theories of liability explored in terms of, environmental or employment spaces. So I think that's something to watch out for. And then, to the extent this ties in, it seems sort of a very specific issue, but I know there's a number of folks on this call that are aware of the recent e-scooter and e-bike tragedies that we've had in New Jersey, and then how that sort of plays in too. And there's certainly going to be some regulation and requirements that are going to be looked at regarding those. So I think that how it ties into liability verdicts is something we'll probably see in the next year or so.
I'm going to put you on the spot here, Adam, and just on that e-bike thing. What do you put the chances of e-bike legislation in the lame duck?
Being introduced 100%. I mean,
Yeah.
it's already been telegraphed that it's going to be dropped in. The Senate president is, and he's one of the ones that's championing this issue. I'd say he is actually a very pragmatic legislator, so this might be the first step in having opening the conversation to see where things go. But yeah, we're going to see at least one, if not two, new bills. I mean, probably as soon as next week. They're hosting a quorum call, which is going to show what priorities they want to focus on in lame duck. So I think that's certainly we're going to see new bills as soon as next week.
Excellent. Thank you. I appreciate that. Well, we're just about an hour. So before I close, I guess I'll ask the panelists, do you have any last thoughts you want to share with our, I guess, with our guests here, with everybody who's joined us? If not, I can open for questions, and then I'll let everybody go. I'm realizing everybody's time is valuable. So panelists, anything last thing to share?
I just want people that we're doing things to counter what we're seeing in the industry. So
Yeah.
don't lose hope. And there's things we can do and customers and insurers can do as well to be influential. So we'll figure this out at some point.
I should mention that PIA has a ton of resources on social inflation and third-party litigation funding as well in terms of talking to your clients about this, right? It's a complicated topic, right? We've been talking for an hour, and I don't know if I'm any closer to understanding it than I was an hour ago, right? Just because there's so much there. So we do have some consumer flyers to help to explain this, what the practice is, and how it does impact insurance premiums. So Lydia, sorry, I won't cut you off there.
No, I didn't. I had nothing to say, nothing to add, except
Perfect.
just reiterate, just stay on top of things, stay informed, read your newsletters, and if you have questions, reach out.
Right. Well, I appreciate everybody's time. We're at an hour, so I don't want to go any longer. If anybody does have any questions they want to ask, feel free to email the IRC, and I'll make sure they get to the panelists and get you guys a response. But I do want to thank all our panelists, Alexia, Lydia, Adam. Thank you so much for your time and your expertise. I hope that everybody found this enjoyable. This was recorded, so we will be putting this up on the PI YouTube channel. So if you really want to look at this again, we'll be sharing the link with everybody. So again, once again, thank you very much, and hopefully we'll see you guys in the next deep dive.
Thank you, everybody.
Bye-bye.
Thank you.